Thank you for asking me to speak. I know this is an ever-changing law. It has become unknown now with all the new changes, but happy to introduce myself. My name is Rachel Woodard. I'm an attorney at Powell and Gunter in Richland, Washington. I'm a native of Richland. I graduated from Richland High back, I don't want to date myself, sometime back there, moved away for a little bit and came back, and I've been practicing law in the Tri-Cities for, I think we're at about 17, 18 years. I have kids that are bombers now, and for those of you who know the Manalopoulos name, I hopefully won't be held against me, but that is my father. Chris Manalopoulos is my father, so those of you who know him, that is I know a lot of realtors that way through that connection. Would you like me to get started with dive in right now, Rosalind?
Yeah, we are good to go.
Excellent. So Rosalind asked me to talk about landlord-tenant law, and many of you probably have to deal with this at a time or two, or many of you actually own rentals yourself. And as you've probably either witnessed yourself firsthand or heard, the law is changed, and it's changed quite dramatically. So back in, well, when COVID started, the governor started putting bridges out, or proclamations out there, to basically prohibit anyone from evicting any tenants, any Airbnbs, any campgrounds, all of that. And that lasted until July or June 30th of this year. Well, during that time, the legislature got together and they passed two new bills that affect and dramatically change landlord-tenant law. So in May of 2021, the House passed, let's see, I think it's 1236, House Bill 1236, and then the Senate Bill 5160. And that was enacted in May and effective right when it was signed by the governor. So we had to basically figure out how to still deal with the proclamation that was out there, and then all of these new laws that were just enacted, and try to figure out how we deal with landlord-tenant. Since then, it's gotten a little bit easier because I don't have to look at so many different pieces of law because the proclamation has now expired. The governor did extend it with a bridge, but that bridge has also expired in October 31st of this year. So now we're really only dealing with those two pieces of legislation that were enacted back in May. Once again, House Bill 1236 and then Senate Bill 5160. Those in themselves, even without the proclamation and the bridge, those in themselves has changed landlord-tenant law dramatically. So we're just going to dive right into this landlord-tenant. I'm happy to take questions if you want to put it through the chat, or you just want to wait until the end. Either way, I'm up for both. I'll try to cover as much as I can, and the applicability of it is still unknown. I've been going to court. We'll talk about that at the end on what I'm seeing at court, but let's just dive right into, we'll start with House Bill 1236. So if any of you know landlord-tenant law, we used to always love month-to-month tenancies because we could do a 20-day no cause. Didn't have to be for a reason. Off they went. We could get rid of a tenant, giving them a 20-day notice to quit. We're just done at the end of the month. Well, now the legislature has decided to take that completely away from us. That's gone. We can't do that anymore. No more no cause evictions for month-to-month tenancy. Once again, only for month-to-month tenancy. So where is our relief? They gave us one little bit of relief, and they said if you put people on year leases or term leases, you can use a 60-day no cause notice. So they have given us a no cause eviction process, but it's only when you give people term leases. So usually you'll see it, brand new person comes off the street, you offer them a year lease. At month 10, you say 60-day notice. Hey, it was nice, but I'm going to terminate at the end of 12. You give them a 60-day notice. You don't have to have a reason. It works just like the 20-day notice did, and off they go. As easy as I'm saying it, that's about the easiest way to get rid of anybody nowadays, and it's really not even that easy. But that's the easiest way. The problem with that one is you have to deal with bad tenants for that full year. And that's the problem that landlords will run into now, because they're not able to just simply give a 20-day notice to get rid of tenants on a month-to-month contract. So what do we do with those month-to-month tenants? If you still have clients that just want to have month-to-month tenants and they're causing problems and they want to get rid of them, well, now you have to figure out a way. There has to be a reason why. It can't be for no cause. In the new statute in 1236 House Bill, I think they lay out 17 different reasons. And we'll go through each one of them and tell you the reasons how you can get rid of month-to-month tenancies, or even if they're on a term lease, you can utilize them for this as well. First one is obvious, a default rent. If they're back in they're behind in rent, it's a 14-day notice, pay or quit. Now, I say that with that caveat. In House or Senate Bill 5160, which I'll talk about next, it's not a 14-day notice right away. The new law has required us to offer them a repayment plan before we can even get to a 14-day pay or quit notice. So I'll talk about that more when I get to 5160, but I want to give you that caveat when I first talk about non-payment of rent. So you can get rid of them for non-payment of rent. Next one is if you have anyone on subsidized housing and there's a breach of that subsidized housing, whether or not they didn't fill out their new contract, whether or not they're not abiding by their contract within their subsidized housing, you can evict them for that. Number 3 is waste and nuisance. We had it before, we can still utilize it now. They've kind of expanded it a little bit and added criminal activity in that. And also they've added repeated and unreasonable interference with the use and enjoyment of the premises. I like it that they've broadened that waste and nuisance issue, but I've been finding at court it's not, it has not fared well as I've liked at court with our judges. So waste and nuisance, if they're committing a waste, if they're committing a nuisance, criminal activity, 3 days notice that you give them to get rid of them. The tenant, if you want as a landlord, if your landlord or your owner wants to move into it, it's a 90-day notice. So they give them a 90-day notice to basically move into the place. That the only caveat there is that there's no substantially equivalent unit that is vacant. So let's say they have a fourplex and they want to move into one of the 3 or one of the 4 of the fourplexes. There can't be another one that's substantially equivalent that they can move into. I haven't seen that played out at court, but I'm sure we'll see that. So if your landlord owns a lot of properties and is trying to utilize this part of the statute to get rid of basically a tenant that they have no other way to get out, so they'll just move into it, understand that they have to be able to say why there's no substantially equivalent vacant unit that they own. The next one is, and you probably see this a lot in your guys' line of work, is a 90-day notice to sell. So if a landlord, if your client has a property that has a tenant in it and it's more lucrative to get them out before selling it, they have to give that person 90 days. 90 days to vacate before they sell it. Now, many landlords ask me, well, I gave them the notice, now can I put it up for sale? Well, absolutely. Your problem will be is you have to get rid of that tenant before this deal closes. You can't sign closing documents until that tenant is out. I've had many clients call me and say, well, the seller gave the 90-day notice to sell. And I said, yes. And he already sold it with you, with the tenant in there, you're stuck with them in there. So understand when you're dealing with clients who would like to sell and they've got someone in there, that they have to completely get them out of there before they close on that house or apartment or whatever they're selling. Because then if they sell it with the tenant still in there, the buyer just welcomed a new tenant and has to utilize the statute to get them out. Okay, so in that same sentence of the 90-day notice to sell, there's also other parameters. That client of yours who gave a 90-day notice also has to put it up for sale 60 days. I believe it's 60 days. No, it's within 30 days after the tenant has vacated that it has to be listed. So many clients who say they're going to sell it, they already have a realtor, and so they're already putting it up for sale. But understand, if your client says, well, I want to look at it and see if I need to fix it up before I put it, on the market for sale, understand that they have to put it on the market within 30 days after the tenant has vacated. So once the tenant is vacated, the clock starts for them to put it on the MLS. Let's see, the next one is 120-day notice if your client needs to demolish, rehabilitate, or change in some fashion. So many clients say, well, I want to do a full-on makeover. I want to completely gut the kitchen, do all that. It's 120-day notice, but understand that the definition of rehabilitate requires some sort of permit that they get from a governmental agency, so that the judges understand that it wasn't just I went in to paint it and I just wanted to get rid of that tenant. It's some pretty big project that they're wanting to change within that house in order to utilize that statute. Demolish, obviously, that's easy if they're just going to get rid of it and sell it as a blanket piece of land, or even if they're going to build a new house there, it's still 120-day notice. Number 7 is conversion. If they want to take a house and make it into an apartment, or they have to give I think it's still 120-day notice, but conversion means we're taking it from apartments and moving it into condos, taking it to a house and moving it into maybe a couple of apartments. That you can get rid of a tenant in there to make that conversion happen. Number 8, hopefully none of you have. If the premises have been deemed uninhabitable by a local agency, you can give them 30 days notice to get rid of that tenant. If it's deemed uninhabitable and the local agency says you got to get out within 10 days, the statute allows you to shrink that time to fit within that governmental agency's assessment of the property to get rid of the tenant. If that ever happens to one of your clients, the law is not very favorable to those poor landlords who have an uninhabitable place, and there's a statute out there that really kind of nails them financially to help that tenant find somewhere else to live, and there's a little bit of punitive damages. I think, if I remember it correctly, I think it's either $500 a day, or it's either $500 or $1,000 a day. So that one's not a pretty one, but hopefully none of your clients have uninhabitable places. Number 9, let's say your client lives with other tenants within their house, so they rent out rooms. This statute is for them. This is brand new. We didn't have it before. It's a 20-day notice to terminate a roommate. So it's pretty nice. I've actually used it more often than I thought I was going to utilize it. But if your landlord shares a home with somebody else and would like to evict them, it's only a 20-day notice. It's pretty nice. It does say in there that they have to share a common kitchen or bathroom area. So understand that if they have a basement that they never commingle, they never come upstairs, they have an outdoor entrance, I don't think that's considered a roommate. This is most of the time deals with if you're renting out rooms. Number 10 is transitional housing. Probably not very many of you deal with that, so I won't cover that in detail, but it is in there. Now, a new lease, if you are going down the path of that you are doing term leases. So you sign up a new tenant and they're on a year lease and you want to keep them on a year lease in order to utilize that no cause notice. And the tenant decides they don't want to sign a new lease. Well, you can evict them as long as you properly gave them notice. And it's 30 days that they have 30 days to sign a new lease. If they don't sign the new lease, you can evict them for not signing a new lease to get on a term. So many clients have complained, well, I got them on a term lease and then they said they won't sign a new one. Well, the statute has now protected landlords as long as they do the process correctly, that this term tenant who wants to go month to month cannot, because a landlord can utilize that 30-day notice to sign a new lease. That new lease requirement is not applicable to month-to-month tenancies. And so if you have someone on month-to-month and you would like to make them sign up for a term lease, you can't force them to do that. You're stuck with them on a month-to-month until you can get rid of them, which is not a fun predicament. And it makes it really hard because then you have to utilize one of these other 17 reasons. But understand that that new lease option for a 30-day sign a new lease is only for term leases. Number 12, 30-day notice if they misrepresent on their application. So the misrepresentations have to be material and they have to be intentional and knowing. So I don't think it's that they make $40,000 and lost their job. I think it's they never made $40,000 and they made $18,000 and they lied on their application. So that's an intentional knowing misrepresentation. It can't be a spelling error. It says material. It can't be a spelling error just because their name is Jackson and they didn't put an S-O-N and just put an O-N. That's not a material misrepresentation on their application. 13 is an interesting one. I have not utilized it. I actually I have one that I'm going to probably do this week, but the next one is good cause. Any other good cause. I don't understand what the legislature was trying to do here, but they've kind of given us this catch-all, this for any other good cause. They talk about how it has to constitute a legitimate economic or business reason. So I don't know what that's going to mean. I don't know what our judges are going to do with it. I have one that I'm going to try to utilize and fit in this box in the next couple weeks. But it's this last catch-all, which is a 60-day notice for other good cause. Number 14 is 4 or more violations. If any of you have dealt with mobile home parks, you probably have heard of this type of statute, but they've added it into the residential landlord tenant law now. So let's say you have a stubborn tenant that keeps on violating, keeps on having occupants over when they're not supposed to, and you keep on giving them 10-day compliance, 10-day compliance. Well, now the statute says if you have 4 or more within a year, within a 12-month period, you can evict them off of that. So you have a month-to-month tenant that keeps on getting 10-day notices. They have unauthorized occupants and then they get rid of the occupants and then magically they come back the next month. So you have to give them another 10-day notice and you keep on playing this cat and mouse game. Now the law allows you to evict them based on 4 or more violations. There is some specific rules that you have to follow if you're going to pick that one. The statute is very clear on you kind of have to do A, B, C, and D in order to utilize this part of the statute, but understand it's there. And it's nice because many tenants knew that they just had to cure their defect within the 10 days or not do it again after the 10 days, and they got to stay. Well, now it's if they keep on doing the same thing, we get to finally evict them for that. Number 15 is new as well. If the tenant did not tell you or did not register as a sex offender during their tenancy, you can give them a 60-day notice to remove them. So if they were required to register and they didn't, you can give them a 60-day notice to evict them. Or if they became a sex offender during the application period, or during the rental period, you can give them a 60-day notice to evict them. Unwanted, number 16. Number 16, I can't wait until this plays out because I don't know how it's going to play out, but it's new as well. It is unwanted sexual advances. If the manager, the property manager, the property owner, the property employee, or another manager is sexually harassed by the tenant, you can give a 20-day notice to terminate that tenancy. Now it seems a little bit like divorce law, like he said, she said, but it's there. If there's any sort of harassment, the law has given us a 20-day notice to evict them, which when we talk about how to evict them, you've heard how many days notice all these notices, 120, 90 days, 30 days, 60 days. This is a 20-day notice. It's the fastest besides a 3-day waste and nuisance notice to get people out. So the legislature found that to be serious enough to give us, quite frankly, a quick route to get a tenant out. If you have this other one is new, and unfortunately I've used this one a lot and I'm frustrated with this new statute, but let's say the tenant moves and leaves occupants in there. We used to just be able to evict them, get out. You had no reason to be here. You were unlawfully in here anyway because you're not on the lease. Well, now the legislature is requiring us to offer them a lease, offer them to apply and see if they can be a tenant as well. It's extremely frustrating. Half the time when I serve these notice, I don't even know what the occupants' names are. But the statute says now we have to offer them a lease and give them 30 days notice to come forward and apply. Now, mind you, if they do the application and they're not applicable, you don't have to take them, but you have to give them the option to sign up and do an application, which I think is frustrating. So the legislature is requiring us to hand those out and wait 30 days. And if we hear nothing, then we can evict them after that. But once again, a longer waiting game. So those are the 17 reasons how you can evict someone. The last part of this new statute is a doozy. If the landlord is wrong in any of these sections of these 17 reasons, the tenant is entitled to the greater of their economic or non-economic damages, or 3 times their monthly rent. So if the landlord just decides, I had a client call me and say, this guy is giving 24-hour notices to terminate tenancy. No, oops, no. Now that landlord who's handing out 24-hour notices to terminate tenancy could be liable to the greater of these tenants' economic or non-economic damages, or 3 times their rent, whatever's greater. So understand that when you're advising people on what to do, the legislature has not only made it hard for us to evict, but then they put this nice little caveat in there and says, and don't screw up, by the way, because if you screw up and if you're doing something completely wrong, that tenant can go back and get quite a bit of money from you. Okay. Now, if the landlord is offering or did a good cause 60-day notice and did it in good faith but lost at court, that's not applicable here. What's applicable here is what I talked about first, a 24-hour notice to terminate tenancy. He's just being ignorant of the law, not trying to know whether or not how to evict, all those kind of things. I would believe that that would be grounds for some sort of liability on the landlord's part. Okay, so let me, before I go to the next section, it looks like I have some questions maybe. If they have a lease that goes past the period that the landlord is selling in, do they still have the renter's right even with the 90-day? Great question. So if your landlord comes or your client comes to you and says, I want to sell this place, I have a tenant in it, and they have 6 months left on a year lease. I want to give them a 90-day notice to sell. Your answer is no. Well, yes, you can sell, but you sell with the tenant in there. You can't get rid of that tenant until the tenant's lease expires. So typically what I would suggest you turn around and tell your client, well, in 6 months, back it up to 3 months, we're going to give them a 90-day notice that terminates on the same date that their term lease terminates, so that we can sell it the day, or we can evict them the day after their lease expires, because we gave them the proper notice that we were going to sell it. Okay, so great question. You can sell it, but you're selling it with a tenant in there, and that new buyer would assume a tenant in there, would have to honor that lease until it expires, and then they have to utilize one of these 17 reasons we just got done talking about to get rid of that tenant. Okay, let's see. Can we get a copy of the rules? Someone already attached that. And just to clarify, these notice times are at the end of the lease, except for the 3-day and the 20-day. You can't decide in the middle of the lease to serve a 90-day owner for the, yep, I think I addressed that. Now, if they're not paying rent, it doesn't matter if they're on the term lease or not. Sexual harassment, it doesn't matter if they're on a lease or not. Waste and nuisance, doesn't matter if they're on a lease or not. I believe if the 10 or more, we talked about the 4 or more violations, that would be at the end of a lease period. So you couldn't breach the lease in the end because they keep on violating. You'd have to wait till the end of their lease. But there are some that you can utilize to break the lease. Non-payment of rent, sexual harassment. The roommate one would not. You'd have to wait until the end period of the lease. I'm trying to, let me look back at the other one. Sex offender, misrepresentation on the application, I believe you can get rid of them in the middle of the period. There's not much. Let me just look back at the other one. There's not much that you can do to breach the lease in the middle of the term lease. It goes back to the premise that I talked about at the beginning, is that these 20-day notices for month to month were so nice because we didn't have to deal with the tenant that long. Well, now they give us 17 reasons to evict a tenant, but many of them were required to hold on to them for their whole lease and then finally be able to get rid of them. So it is a big change, but there are some ways to breach the lease in the middle, but not much. If the landlord offers the lease, or month to renew, but offers it much higher payment, how much can they raise the rent? i.e., have been paying $835 a month and now wants to raise it to $935 on a year lease, or $14 on a month to month. Is that legal? Well, I think I understand it. So first, there's no rent control in Washington. So that means you can raise it as much as you want. Now, if you want my advice, I'd raise it to market value so that it doesn't look like your client was trying to constructively evict a tenant by just simply raising the rent. Now, I have not seen that play out in courts, that would be an argument that I would utilize if I was a tenant, that they were just raising the rent to an absurd amount just because they wanted to get rid of me, and they couldn't find one of the 17 reasons in the new statute to get rid of me, so they just kept raising my rent. So I would worry about that side of it, but I'm going back to there's no rent control in Washington. So there's no, you can go as high as you want. You can double it, you know, whatever the case may be. But let's go back to what she's asking. If we are in a term lease and she's giving a 30-day notice to get on another lease, how much can you raise it? In the statute, it says it has to be reasonable. I don't know what that means, but doubling it probably isn't reasonable. Going to fair market value probably is reasonable. But understand this, if you want to raise the rent, you're going to have to give a 60-day notice. It can't be in that 30-day notice to offer a new lease. Confusing? Yes. Are we going to get it? I don't know. So if you have, let's go back to the year lease scenario. You have a client that's on a year lease or a tenant that's on a year lease, and you want to raise the rent and offer them a new lease. You're going to back it up to month 10, and you're going to give a 60-day notice to raise the rent and a 30-day notice. Here's a new lease. I know the 30 days is way earlier than 30 days, but we'd rather have that than you forget about raising the rent. So you have to give a 60-day notice to raise the rent, and then you give a 30-day notice to offer the new lease. But specifically in the statute, it talks about that it has to be reasonable. I don't know what that means. Yes, we'll wait for, some court to decide to litigate that one. Okay, let's see. So I think I answered that question. What's the most advantageous term for landlords? Well, I think it's term leases now. And it's sad, but I think that's what it is. And I think you go with a year lease. You can go as short as a 6-month lease, but there's quite a bit of nuances in it that landlords are not getting. They don't understand the nuances with the 6-month leases. So if you have a landlord that only dabbles in this here and there, I would tell them to stick with year leases. If you have an apartment complex that utilizes this statute a lot, then they can offer those 6-month leases because they'll know the nuances within the law to offer 6-month leases, and they will pay attention to the timeframes and the leases that they offer. It's a little bit confusing, and I think the legislature did it on purpose to make it confusing so that people would not choose a 6-month lease. So I would go to a year lease and be able to utilize a 60-day no cause at the end of that year. Is proof needed for sexual harassment? Well, yeah, absolutely. And that's what's so hard about it. It kind of reminds me of divorce court. He said, she said. And that's really what's going to happen. We'll talk about that when we get to 5160 about what I see at court now. Is there a limit to raise the rent? I believe we talked about that. Number 13, good cause. Is that a 60-day notice? Correct, it is. Any benefits to a month-to-month lease? Well, I don't know. So the only benefit that I see to a month-to-month lease is that you can give 60-day notices to raise rent constantly. That's the only benefit that I see, is that it's a 60-day, or it's, you can raise their rent. You don't have to wait till the end of the term. Right now, if we offer year leases, you can't raise that rent for a year. If you're month to month, you can raise that rent every 60 days if you wanted to. So I don't think there's any advantages outside of that anymore. It's really sad, but really that's the only advantage that I see to month now, because there's no 20-day notice to terminate for no cause. Can I raise the rent in the middle of the lease? Nope, I just answered that question. Okay, and let's go on to the next fun section. And that's sarcastic if anyone picked up on it. So the next section is 5160, or the next bill is 5160. One of the other ginormous changes that they made, that the legislature made, is that every tenant is afforded a free attorney on our tax dollars. It says that the tenant has to be indigent, which means I think 200% below poverty, but if they receive any governmental assistance, they are automatically afforded a free attorney. What that means for your clients is, when we just had the question about, do we have to have proof of sexual harassment? Well, now you have an attorney on the other side fighting for the tenant, saying that that never happened. There's no proof. So now you have an attorney on the other side fighting every single step of the way what you're trying to prove in court. It makes it a lot harder to win the he said accounts at court, because you have an attorney on the other side. And so because of that, there's quite a few ramifications, and one of the biggest ramifications is the time frame. I will go to court and the tenant will show up, and the tenant will say, well, I don't know if I'm applicable to a free attorney. And the court will automatically grant a 2-week continuance to see if they're applicable. So now when I go to court, it's not, I don't get any resolution for my client. And so I come back 2 weeks later, and they now are appointed an attorney free of charge. And guess what that attorney is asking the judge? Another 2 weeks so I can read the file and figure out what our defenses are, Your Honor. So the time frame has blown up in getting an unlawful detainer from start to finish. So that's one of the biggest changes, and it's here to stay. There's a couple things in the statute in 5160 that expire, but this right of counsel is here to stay. And the right of counsel, the tenant doesn't have to pay. So I've had their attorneys come to me and say, we're going to appeal this. Well, that does no benefit for my client, but benefits their clients all day long, because one, their tenant doesn't have to pay for that appeal. And two, they get to sit in that place until the appeal is resolved. So it's been a ginormous wedge in the time frame of unlawful detainers. If you guys know much about the law, if a regular lawsuit happens, the defendant gets 20 days to answer. In a typical lawsuit, whether it's a slip and fall case or a contract case, they get 20 days. In a landlord tenant law, that summons is only a 7-day summons. And the legislature, when they created landlord tenant law, they said, we want these landlords to be able to come to court faster, because their whole idea is making money, getting people in and out. So they made this summons a 7-day summons to get us into court faster. Well, this right to counsel has completely blown up that whole premise of the faster to get to court, because it just takes that much longer. So the other big change in 5160, we talked about default and rent. And I said, oh, it's a 14-day notice, but you have to do a repayment plan first. So under 5160, they talk about this repayment plan option. Well, a requirement that you have to give tenants who are behind in rent. So if a tenant's behind in rent, you have to offer them a repayment plan. This will expire in 2023, it expires as far as having to offer the tenant this repayment plan, I believe expires in 2022. But if any of their rent is from COVID, March of 2020 till now, you have to offer them a repayment plan. The repayment plan has to be their current rent plus only 1/3 of their back rent of their monthly rent. So if they owe $10,000 in back rent and their rent is $900, you can only give them a repayment plan that says pay your current rent of $900 plus $300 towards the back rent of the $10,000 you owe. Yes, it takes a long time at $300 a month to make up the $10,000 that they owe. But that's what the legislature said. It can't be any more than 1/3 of their rent. So can't be any more. So some tenants were saying, well, I'll pay you $900, but $25 is all I can afford for the back rent. Because it only can be up to 1/3, but it can be less than 1/3. So we have been doing these repayment plans, and they're messy and yucky, and some tenants are ignoring us, other tenants are signing up and failing. It hasn't been a great process, and I'm quite frankly excited to see it leave, but I can see our judges wanting our clients to still offer these repayment plans. I just don't know how long they're going to want to see them. So the next part of the process in 5160 is the Dispute Resolution Center. It's called ERPP, and it's called, it does stand for something. It's Eviction Resolution Pilot Program. Each county in the state of Washington had to adopt this ERPP program. So basically our county, when did they did their standing order, I think in October. Basically, the judges in Benton and Franklin County are saying, okay, after you give a repayment plan, I'm going to need you to go to Dispute Resolution Center and figure out if you can mitigate or work out a settlement on this back payment of rent. So here we offer them a repayment plan and they ignore us. Then the court has said, well, you're not done yet. You don't get to go to court yet. You have to go to mediation. Mediation is not what we thought it was going to be. It's actually working out better than we thought. Mediation, the dispute resolution, is basically going out and finding money, free money that our governor has given to certain organizations to help out tenants who are behind in rent. So dispute resolution has been finding money for back rent. So it's ended up working out more beneficial than we thought it was going to look. So when we send our case off to dispute resolution, we're not sitting down with them in a mediation the way that we thought. We actually don't sit down with them at all. We send it all via email and they start calling. Once they get a hold of the tenant, they have the tenant fill out applications and they go find the money. So that scenario where I talked about $10,000 and they only pay $900 in rent, the dispute resolution actually goes and finds that $10,000 and pays the landlord up in full. And then I've been seeing now more recently that the landlord's getting 3 months ahead as well. So they're paying all the 10,000 back and then they're paying 3 more months. And so it's been a great process for tenants who are really behind in rent. And it's great for landlords too. I mean, the $10,000, they don't have to wait 3 years at $300 a month to get it. They're getting it all up front. So it's been a better process than I thought, but now it's getting bottlenecked because they're busy. You know, landlords are starting to figure out that they can go to court and evict people for non-payment of rent. So the DRC is busy. And so now the backlog, we don't see money or we don't see applications for money for about 2 to 3 weeks. And they don't even give us it's TRAP and ERAP money. I don't know what they stand for, but it's federal, it's state funds and some federal funds. But we're not seeing those contracts that the landlords basically say, yep, they owe this amount of money. This is what their rent is. The landlord signed that document, usually give a W-9. We're not seeing those for 3 to 4 weeks now. It used to be a faster turnaround than that. So that's another big part of the law that's changed. So it's not just a 14-day notice, pay or quit anymore. We have to do all these steps before we get to go to court on that non-payment case. Other than that, I talked about the ERPP program, the 14-day, we talked about that. I get a lot of questions and about cash for keys. We used to do that. You know, I used to tell my clients all the time, offer them cash for keys. I think we can still do it. I'm a little worried about that caveat that I told you that a landlord, if they do something in violation of the statute, would be awarded 3 times their rent or whatever is greater between their economical and non-economical damages. I'm a little worried there, but as long as the tenant is consenting to for them to receive money to move out, I think we're still on the right path. But I'm giving the caveat because these attorneys that are representing tenants at court are good at their jobs, and they might try to make a decent argument to try to fit that box into that, you know, into that it violates the statute. We're not using one of the 17 reasons to get rid of them. We're trying to pay them to leave, and we're trying to forcefully pay them to leave. But I think as long as the tenant is in consent, I think that cash for keys might still be applicable. But understand, I'm giving you that caveat because I see that there might be an issue there. Let's see, questions. Let me make sure I have covered all of 5160. Late fees. Many people thought once the bridge expired in October that they could start charging late fees on rent. That is not true. They can't start charging late fees until 2022. I get a lot of those questions. It says right in the statute that a landlord may not charge late fees from March 2020 to 6 months following the expiration of the eviction moratorium. And as I told you in the beginning, the eviction moratorium expired in June 30th of 2021. So add 6 months, you get stuck in 2022. So tell your landlords that. I know that some landlords are putting it on their piece of paper that they owe the late fees, but I think that's just flat out wrong. I think they have to take those off. They can't charge those late fees until 2022. All right. Let's see what other questions you have. Also to clarify, I think I just did that one. Is there a statute of limitation for tenants in a case the landlord did not do notices appropriately? So if you mean that the landlord gave a 14-day notice without doing a repayment plan, and they somehow snuck it through the judge and got a writ of restitution. I believe there's a statute of limitations on that. But off the top of my head, I don't know what it is. I want to say it's 3 years, but don't quote me on that. I've never seen that. What happens is our judges are they're pretty good. They're pretty good on the process, and they'll catch it at some time. And if they don't catch it, those free attorneys for the indigent tenants will catch it. Let's see. After the lease term is up, does it automatically go into a month-to-month, or do you have to do something in writing that says it will be month-to-month? It does automatically go to month-to-month. Even if your lease says it expires on the date it expires, I think that it can be construed that it goes month-to-month. There still is a holdover statute in the landlord tenant law, and I just don't know how that'll play out. Holdover tenant means the lease expired. There was no extension on the lease, and you're still there. We used to be able to give a 3-day notice that you're a holdover tenant. You held over longer than your lease. Well, now the new statute in the House Bill 1236 seems to kind of take that away, where there's a premise if the lease expired and they're still there, it looks like it's a month-to-month tenancy. So I would play on the safe side and not let it expire without giving a proper notice to terminate the tenancy with a 60-day no cause eviction to terminate the tenancy. If a tenant's on a month-to-month lease and after 6 months decides they want to leave, what are the tenant's financial obligations to the landlord? Well, they're required to fulfill the lease for the rest of the 6 months. But the landlord is required to mitigate the damages by trying to figure out if they can find someone else to fill their spot, get them an application. But the tenant's responsibility is for the full 12 months. And so the landlord just can't sit there and say, you can go ahead and leave, but I'm going to nickel and dime you all the way to 6 months. I don't have to do anything. They do have to try to mitigate the damages, which means put it back out wherever they advertise for the rental in the first place, put it back out there and see if they can find someone for the rest of the 6 months. But the tenant's obligations are for the full year. Do we need to offer payment plan options prior to posting a 14-day pay or quit? Yes. Yes. My understanding is that it can be done at the same time as the 14 days is posted. So it's a great question. When I first read the statute, Alice and I read it the same, that I could give a repayment plan and a 14-day pay or quit notice all at the same time. The attorneys that show up at court, they disagree with me. And because they disagree with me, I don't want to argue with them, and I don't want to go to the appeals court and fight all the way to the Supreme Court of Washington on whether or not a repayment plan has to be issued before a 14-day. So guess what I just do now? My practice is to give a repayment plan, wait after the 14 days is run on the repayment plan, then do the 14-day pay or quit. So I read it that you can do both, but I didn't want to fight with the attorneys that I'd see at court, and they will appeal it if they're wrong. They won't just take that they lost at court. They'll appeal that because they feel like that gives that tenant longer to be in there. So they would appeal that poor landlord who just, served a 14-day notice with a repayment plan just to get the tenant out, still doesn't have any money from the tenant. And now we're at the appeals court of Washington to fight whether or not the repayment plan had to be served 14 days before the 14-day pay or quit notice. So my practice has been now just to do one, wait, and do the other. My whole practice revolves around how to get a tenant out as fast and as cheaply as possible. So I do talk to the attorneys that are representing tenants quite often to see what they're passionate about, because I don't want a landlord to win at court and get a notice of appeal from these attorneys. It just is not advantageous for any landlord. It's not making them any money. It's not helping them at all. So sometimes I acquiesce to some of the things that they find are passionate, even though I disagree, just because it saves my client money. Okay, next question. The repayment plan is tricky because if they get behind again, you have to offer them another repayment plan. So yes and no. I have offered them a repayment plan. And if they fail on the repayment plan, then I give a 14-day pay or quit based on that repayment plan. Where I see that you have to offer it again to them is, let's say September, they're behind in rent. You offer them a repayment plan. They say yes. Well, their first payment is not due for 30 days after you offered it. So September 5th, you offer them a repayment plan because they haven't paid September's rent. And their first payment on that repayment plan is not due until November 5th. Well, now November comes along and they didn't pay their rent. Well, you'd have to offer them a new repayment plan for the new rent that they just didn't pay. It seems stupid. So what I do is I simply wait until the repayment plan first payment where they fail to do so, and I go off of that. Now, the tricky part is if they pay on the repayment plan, but they don't pay you the monthly rent, then you have to offer them a new repayment plan. But it's stupid, it's tricky, it's not fun, and I don't enjoy doing them. But part of the new law. Does the ERPP expire in January of 2022? Well, some of it and some of it not. So the DRC, the dispute resolution, which is part of that ERPP program, goes until July of 2023, I believe. Double check that. July 1st of 2023 is when it expires. So what I believe expires is the requirement to offer the repayment plan. So when we get to January 1st, I believe we don't have to offer repayment plans, even though I think my practice is going to be to offer a repayment plan with a 14-day pay or quit, but I don't think it's required. Tenant is out. Tenant owes $29,000 in unpaid rent. What is the best way to try to get some of that back? Well, there's a lot of free money out there. The problem is the tenant has to engage at some point in the process. There is a landlord mitigation program out there. I don't know enough about it. I spend a lot of time telling my landlords to talk to other landlords to figure out if they're getting money. I have heard some are successful, some are not. The traditional way before all of this COVID stuff happened was to get a collection agency, just like what you used to do, a collection agency, and have them go hound them. On a month-to-month lease, do you have to give a 60-day notice to terminate? No, you cannot terminate a month-to-month lease with a 60-day notice. Let me say it again. You cannot terminate a month-to-month tenancy with a 60-day notice. A month-to-month tenancy has to have a reason. That's why they're not advantageous anymore. Is there an official repayment plan that needs to be initiated by an attorney, or can it be a simple written request to the tenant to repay the back rent? Well, it does not have to be done by an attorney, but it has to be done per the statute. And the statute is very specific. It has 1, 2, 3, 4, 5 elements in the repayment. You have to serve it like any other notice. So you absolutely can do it yourself, but by the time you get to an attorney, the thing that I always advise, by the time you get to an attorney, you've just wasted 28 days because you've done the repayment plan by yourself and you've done the 14-day pay or quit by yourself. And if you did any one of those wrong, the attorney is going to tell you have to start over from the beginning. And that's 28 days to start over by the beginning. No one likes to start over. Okay. So there's not an official repayment plan form. What is the average cost for an owner to hire you to get a tenant out? Very good question. Because of the wonderful new laws that we have and how long it takes from start to finish, I'm averaging between $3,000 and $4,000 an eviction. It used to be half that before all this happened. Is it safe to assume property management companies know 1236? Well, I hope they do. And 5160, I hope they do. I really do. I've been talking, I represent a lot of property management companies, and they're great. They know their place as far as when to ask and when not to ask. And as the process, as we continue to go down this road of doing this process over and over, they'll get better. And so right now I'm doing most of their work until they can get up to speed with the new law. Landlord mitigation funds, thank you. What is the best process to convert a month-to-month agreement to a year lease? Well, I'd say the best process is okay, I'm giving you a 60-day notice to raise your rent to this amount if you're going to stay month to month. If you get on a term lease, it'll only be this amount. So there's no way to force them, but I would say that would be the best way, is monetarily. Well, if you're going to stay on month to month, I'm going to increase your rent to $1,200, where if you sign a year lease, it'll be $1,150 or $1,100, whatever, you know, gets that tenant sparked enough interest to say, yep, that's going to save me some money. I'm going to sign up for that. Anybody else? Okay. I just want to talk about the court experience a little bit. I've been going to court. Well, I've been going to court all through COVID, with only the minor ways that we could get them evicted during COVID. But as I said before, the process is really long, and the attorneys there, they're great people, but really all they're there to do is try to figure out how to keep that tenant in there longer. And they don't care what basis I'm going off of. I've had 3-day wasted nuisance. I haven't had a non-payment yet, but I'm about to, I think in a week. I finally went through the repayment process and the 14-day, and I did the dispute resolution. So I'm now at filing a summons and complaint on those. But I've taken 10-day comply issues. I've taken the roommate issues. The judges are just extremely cautious, and they don't want to give me writ of restitution. And it's making my process harder and more expensive. And so I give that caveat to any one of your clients. And the other thing that I would suggest to anyone out there, because these laws are new and they're hard to apply, and I would simply say, hey, you landlords have the right to raise your rent if they're month to month. Raise it to the point that you're putting away money for attorney's fees, because quite honestly, it's getting to the point where it's these bills were more landlord attorney relief acts, because everyone's coming to me because they are convoluted and they can't do them by themselves anymore. And they get confused about a 6-month lease or a year lease, or, okay, I have a month to month. What can I evict for? What I can't evict for? It's made it so hard for the average person who used to do this for 20 years by themselves. They have to come to me, and I charge money. So I tell them to push it off on the tenant. Push it off on the tenant where it rightfully should belong, because you guys shouldn't have to be out any more money, because most of the time these tenants are not paying. All right, I'm at 10 o'clock. Does anybody have any? Can a tenant get out of a lease if the landlord can get a new tenant? I was told landlord can't double dip. Well, the landlord doesn't have to accept that new tenant. As far as to swap them right away, but correct, they cannot double dip. So if the tenant says, I'm moving out, here's a new tenant, correct, they can't double dip. So if the landlord takes the new tenant and they're applicable in their application, then the landlord takes that new tenant and they cannot double dip, correct. Quickest way is wasted nuisance. How realistic is this option? It's not great. The other part of the process that I didn't really talk about is the police are not, they're great people. I love the police. I have a lot of family and friends that are police officers, but they're not arresting people anymore. They're not helping us show that there's a waste or a nuisance or a criminal activity. So I had a domestic violence issue at an apartment complex, and the landlord or the police came and said, we're not going to do anything because we didn't see anything, and they don't make an arrest. It's extremely frustrating because we need them to make an arrest to help make that stick. And nowadays the police come and they just obviously make sure everyone's safe, put people back in their apartments or their houses, but they're not making arrests. So when you talk about that wasted nuisance, we need a third party to verify what happened. And it used to be police reports, and it's not as much. So it is a realistic option. It's just, you have to have the right fact pattern. Okay. Excellent. Thank you so much. Happy to help anyone individually. you want to know where to find me, I can send my contact information. I believe Rosalind has it. So thank you for giving me this time to talk to you guys. Hopefully I gave you some information that you needed or wanted to hear or didn't want to hear, and be able to pass along to your clients.
Thank you so much, Rachel, for being here today. We appreciate you. Very, very valuable information. So thanks to all who attended. I've gotten many questions about where they will can see a copy of this presentation. We're going to edit down the beginning portion, and then we'll post it on our weekly newsletter and probably on our social media accounts too. So we'll make sure this is available. You can show people at your office who missed this presentation. So that's all I have for you. If no one has any more questions for Rachel, we always give Zoom claps. Thanks, Rachel, for being here so much. Everyone have a wonderful day and a great holiday.